Welcome back. I'm Carissa Kranz. Right now, as you see, there's a live feed in the courtroom. This is the Dyke trial 2014 case where the former cop is standing trial for shooting and killing, and the charges are murder, Laquan McDonald. Right now, the defense is putting on their case, and you just heard Miguel de Jesus from the Cook County Juvenile Detention Center take the stand. We heard direct examination, cross-examination, and redirect examination. One of the key things I picked out in the cross-examination was the prosecutor made it very clear that though Laquan McDonald had a reputation in the detention center of acting up and acting out, she specifically asked, did Van Dyke, the defendant, know about these incidences before that date? And the answer was no. With me is former federal prosecutor Francey Hakes. Francey, I think this is key testimony, and I want to know if the prosecution, in your eyes, did an effective job in throwing down the defense's case with that cross-examination.
Hi, Carissa. Yeah, I think there are two important points here, as you've said. One was the point that the police officer didn't know anything about McDonald when he shot him that night. And so to the extent that McDonald had bad or dangerous conduct in his past, the officer didn't know about it. But also that McDonald had that prior bad conduct, as the defense is trying to say, in his past. I think this is directed far more at the jury than it is at the mental state of the defendant. I think it's designed to show the jury that this was a potentially dangerous person. Of course, we know he was wielding a knife that he refused to drop. And so I think the defense is simply trying to show that he's acted in that same character on previous occasions. Right, and I agree. This is about mitigating factors. The defense is trying to do everything they can to show the jury that Laquan McDonald was a victim, and the prosecution is going and saying that, or that Laquan McDonald was not the victim. The prosecution is doing everything to say that the officer acted with excessive force. So everyone's poking holes in their case. Before this shift, I heard the previous guest say something to Bob Bianchi, the host, that the way he spun around with the knife on the video, it appeared like he was going under attack. We're going to have to go to a quick break, so maybe after the break we can talk about this, but I want you to think about it during the break. What I saw on the video, and maybe we could replay the video at some point, was him getting shot and then spinning around with the knife. So I think there's some question on timing here, on which the jury is going to have the opportunity to replay on whether or not it was being spun around and he was shot and then spun around, or did he spin around to go in attack mode? All key things to think about. That's the video on the screen right now. Think about those questions, and Francey, think about that. We're going to take a quick break, but we will be back with our live feed and more in-studio analysis just after these few moments. Welcome back. I'm Carissa Kranz, and on the break right now, you just saw the teaser, which we will be continuing to tease on the network for the Jessica Chambers trial. We will be following that case closely as well. Our very own Kathy Russin is there today for jury selection. She's also available on Skype to give us updates. We are going to be covering that on the network for you, gavel to gavel. That has gripped the nation and social media and all the crime platforms, so we will keep a close eye on that. Also, let's take a look at some other top trending crime stories around the nation.
This time you're out.
Cross-examination.
Okay, we had a little bit of a technical glitch there, so now we're going to go to the top crime stories around the country, and then we will come back for some more in-studio analysis and courtroom testimony.
Here are today's top crime stories trending on Law&Crime.com and across the country. Investigators in Tennessee arrested a man in connection with the killing of his ex-girlfriend, alleging the man faked her suicide to cover up the murder. 29-year-old Jason Riley is accused of fatally shooting his ex-girlfriend, 22-year-old Holly Marie Adcock, before making a fake suicide note and calling authorities. Investigators initially labeled Adcock's death a suicide, but focused their investigation on Riley after discovering threatening text messages to Adcock on his phone. Riley now faces charges of first-degree murder, extortion, filing a false report, and tampering with evidence. A bus driver in Indiana is facing charges after a video surfaced of her allegedly allowing young kids to drive her bus. 27-year-old Jo Andrea McAtee was arrested after the video made the rounds on social media. McAtee was immediately fired by the bus company she worked for, First Student, and now faces a charge of felony neglect of a dependent. 12 more women have reportedly come forward to investigators in the sex assault case against a doctor-turned-reality TV show contestant and his girlfriend. 38-year-old Grant Robichaux and his girlfriend, 31-year-old Carissa Riley, are accused of luring other young women into threesomes when they were too drunk or drugged to consent. Authorities reportedly discovered thousands of inappropriate videos and images on Robichaux's phone of barely responsive women. The couple faces a variety of charges, including rape by use of drugs and possession of controlled substances and assault weapons. Those were today's top crime stories. I'm Anthony Velez for Law and Crime.
Thank you, Anthony. And these top crime stories never cease to amaze me. Every time I watch them, I think to myself, how is it possible that these things can happen? Especially that last story where you see this very good-looking and charming boyfriend and girlfriend who have victims coming forward one after another. There they are on the screen. It might not be the most attractive mugshot, but you can see their features are quite attractive. And not only are they criminals together, they really are partners in crime. Francey Hakes with me. I want to talk about this case really fast. What do you make of the fact that victims are continuing to come forward out of the woodwork as this is getting more media attention? Is this a spin-off of the Me Too movement where victims just keep coming forward after the fact, or is it because of media coverage that people are coming forward, or what are your initial thoughts on that?
I think, Carissa, it's two things. First, I think once people who are perpetrators are arrested, victims feel safer and feel like they have the ability to come forward now. And also, victims often feel like they're the only ones, and maybe they were mistaken. They question their own memories. We see it going on now in the Kavanaugh matter with Dr. Ford and these other allegations where there's some questioning of their own memory, which leads to a delay in disclosure. We see sexual assault cases all the time where there's delayed disclosure. Although, can I just say that I don't think that means we should label people sex offenders on a mere allegation. But the couple here that you're talking about has been arrested. So there's been a probable cause determination by someone, a judge, a prosecutor, in order to effectuate that arrest. So I do think these charges have credibility. And like you said, it is amazing to me what people will do to others.
Right. And you bring up a good point, even with the Kavanaugh, which I know we covered on the network in the last shift as well. There are more victims coming forward now. So I think that speaks to exactly what you just said about feeling safer. There is a delay in disclosure, and people do seem safer in numbers. They have some kind of momentum, and when they don't feel alone in disclosing, they come forward. However, that begs other issues of whether or not there should be a statute of limitations in place, because like the Kavanaugh hearing and even the Cosby case, something else that we're covering here on the network, and then the sentencing. I mean, how far back do victims get to come on hearsay accusations? All interesting things, political and crime related, trending on our network and all networks. Okay, back to our main trial, which we were talking about before the break, before the top crime stories. It's the Van Dyke trial. This is our main trial out of Illinois. This is the case where the former police officer shot and killed Laquan McDonald, a teenager. And that is the video right there that you're watching on screen. And before the break, we were analyzing whether or not that spin right there was him spinning around to provoke an attack with the knife in his hand, or him shot and then spinning around. Unfortunately, the video has no sound, so we have to analyze the video, and we can keep replaying it to try to figure it out on whether or not the video is a mitigating factor for the defendant, the officer, or an aggravating factor for the defendant, the officer. Right now, the trial is the state rested, the defense is putting on their case, and we are listening to defense witnesses come forward and attack the character. And then on cross-examination, we hear on rebuttals that the character of the victim is being attacked in juvenile detention centers. All things that the defendant did not know before he pulled the trigger that day. Okay, with me, Francey Hakes. Let's analyze this video. the last shift, the host, Bob Bianchi, and his guest analyzed it that he spun around and was in attack mode, and therefore it's mitigating for the officer. I'm looking at this video right now, and it looks like he is shot, and that's what causes him to spin around and then fall to the ground. Let's look at that and analyze this together. See, he's crossing the median right now, and up, there you go. Up, there it is, and there's the smoke on the ground. What do you think?
Well, see, Carissa, it's very hard to see, and this is, of course, the point the defense will make, is that it's literally a split-second judgment the police officer has to make. But it does look to me as though McDonald might have been turning to his left. I don't know that you can call that an aggressive move, but with a man with a knife, I can understand why the police might have thought it was an aggressive move. It looks like he's turning slightly to the left and then gets shot and spun completely around to the right when he falls. Now, again, we have no sound. It's impossible to know if there were any shots before that. I can't tell. But I can understand why the previous guest thought that he might have been making an aggressive move, but it's very small.
Well, and one thing you brought up that I thought was interesting and important during the break is you said to me that in these situations where you don't have sound on the video, that the perspective is supposed to be weighed in favor of the officer and not the victim in these cases. Do you want to expand on that thought?
Yeah, so I don't mean it's supposed to be weighed that way. What I meant to say is that oftentimes that's where juries end up. If they kind of throw up their hands, I don't know exactly what happened. We can't tell if he was making an aggressive move before he was shot. Juries tend to give police officers the strongest benefit of the doubt. And if they can't themselves determine what was going on, they get the officer has the benefit of the doubt and they acquit him. I won't be surprised if that happens in this case.
So what about the fact that 16 shots were unloaded on this victim within a matter of 30 seconds of arriving on scene? I mean, doesn't that go to an aggravating factor with this officer, despite the fact that maybe in the video we don't have sound to really pinpoint the exact millisecond of when that shot was fired versus when he spun around?
Well, certainly that'll be one of the prosecution's arguments, Carissa, but
I think it's a good one.
You know, it's not a bad argument, but police officers are trained when they feel there is a threat to them or the public to put the threat down. And that means just firing until the person is down.
Right, and you know what's interesting in this case is the first responders were all there with taser guns. This officer showed up and he unloaded 16 deadly shots. So the question is, was this force justified under the circumstances? Not whether or not, you know, it was right or wrong, but whether or not it was reasonable. We have to take a quick break. Stick with us. Welcome back. I'm Carissa Kranz, and right now on the stand you're listening to testimony of Mark Smith, a paramedic from the Chicago Fire Department. Mark arrived on scene after Laquan McDonald was shot 16 times by the defendant, Van Dyke. This is the trial we're covering right now, and we are listening to testimony. The prosecution is hounding whether or not he was already dead when the fire department and Mark Smith arrived on scene, or was he just non-responsive? And whether or not they were trying to revive him because he was dead or not responsive. With me, Francey Hakes. Why is it important whether or not he was dead and at what point he actually died versus the fact that the officer unloaded 16 shots and whether or not that was reasonable?
Yeah, Carissa, I think the prosecutor is trying to show that it was an unreasonable use of force in the sense that 16 shots, he was almost immediately killed, and there was no chance that he was ever going to be revived because of the brutality of the assault by the police officer. I think that's the prosecution's perspective here.
Right. So the prosecution is hounding then, at this point, we're listening to testimony of them hounding whether or not it was even reasonable to be trying to revive them at the time, it seems. Like he was already dead, right? His heart had stopped.
Yeah, and I think it's interesting that the defense has called this witness, apparently, because the prosecution is the one cross-examining. So the defense has called this witness. Everyone loves first responders and paramedics. And so I think the defense is definitely using that to their advantage and to show that whatever this officer, this Mr. Smith, is testifying to is credible because he's neutral. He's not a police officer. He's not a bystander. He's a first responder.
Right, and how do you think the jury's taking the facts that when he was trying to revive her, or revive Laquan, that there was blood pouring out and pumping out of his chest while they were trying to resuscitate and make the heartbeat come back?
Well, I think it's somewhat gratuitous, but I understand it as a prosecutor. I certainly would have done the same thing to remind the jury that this was a brutal assault, a hail of bullets, 16 strong, against a young man, a teenager, and then his brutal, almost immediate death. I think they're just emphasizing that.
Right, and so even though we're learning that this teenager may not have had the perfect record and that he had been in the juvenile detention center and that he even that night was engaged in some criminal activity, that all of that did not necessarily rise to the occasion of justified, reasonable, deadly force. That is the conclusion the prosecution is getting at here.
Well, that's right. Deadly force has to be justified. And the fact that the officer had no idea what Laquan McDonald's history was is significant, certainly. It shows that his mental state, that is what he knew, had nothing to do with it. And it had everything to do with only the circumstance that he found himself in. Was Laquan McDonald a clear and present danger to the officers or the public, therefore justifying deadly force or not? That's really the only question the jury will answer.
Okay, so right now we just heard from Mark Smith, a paramedic and a first responder. And yes, everyone loves our first responders when they arrive on scene and they do the right thing and they don't use excessive force. Now I want to continue with that thought and listen to testimony from Dr. Pawnee, also from the state, but a medical examiner. And let's hear what he has to say and how this can either, or what she has to say, and how this can either bolster or hurt the prosecution's case. Let's take a look. Welcome back. I'm Carissa Kranz. That's testimony from the medical examiner, Dr. Pawnee, from the state. And she is testifying as to the cause of death for the victim, Laquan McDonald, when he was shot 16 times by the officer, the defendant, Van Dyke, when he arrived on scene within a matter of 30 seconds. This is key because, Francey, why?
Because what they're trying to say, I think it sounds to me as though Laquan McDonald died from blood loss.
So not the gunshots, blood loss. That's what you just heard, right?
That's right. Gunshots, blood loss versus being shot directly in the heart.
Right, or an organ.
Dying that one particular wound. So what they're trying to say is each successive gunshot was excessive in the sense that perhaps he could have been saved if he'd only been shot once or twice or 5 times. Versus 16 times.
I mean, that's pretty amazing. So he was shot 16 times and not one of those fatally shot an organ, and that they're claiming that it was blood loss, which it was the reason and the cause of his death.
That's right. It makes the assault, if you will, if it's illegal, it's certainly an assault. It makes the assault sound more violent. It certainly actually was more violent. And 16 shots to any normal person who's not a police officer sounds excessive by itself. And the prosecution is going to hammer that point repeatedly.
Okay, and I just got news from the control room that we have an update in another trial we've been covering here on the network. It's Stanley Liggins. We've been following this for a few weeks, and we've been covering it gavel to gavel on the network. We have an update in the courtroom right now, and just as a quick recap, this was the 4th day of deliberations, and the jurors could not agree. We have to go into a court. I don't know if they agree now. Welcome back. I'm Carissa Kranz. We had a big update before that break, and it's in the Stanley Liggins trial out of Iowa. This is the case where an Iowa man stood trial for a 3rd time. Jennifer Ann Lewis, 9 years old, was found dead in school in 1990 by a janitor. She was raped, strangled, and wrapped in a plastic bag. This case had very little evidence, and this case is almost 30 years old. There was no direct evidence. It was all circumstantial evidence, no DNA, but despite that, the prosecution tried the case a third time. On Friday, we learned that the jury was having a hard time agreeing. They sent a note to the judge. The judge then told them to try to rethink and have an open mind. They asked to leave early for the day to ease the tension. The judge didn't let them leave early until 4:30. They are back today, and after an almost full day of deliberations, they just come back saying we are deadlocked, which means mistrial. With me, Francey Hakes. Let's talk about this for a minute. Okay, this is a man, a defendant, who has spent 28 years behind bars for charges that have 3 times either been dismissed, overturned, hung, mistrial, you name it. What's going to happen now? Are they going to try this case a 4th time? Or is he going to get a time-served plea and walk? What do you think?
That's a really tough call for the prosecution here, Carissa. You're talking about a 9-year-old little girl who was brutally raped and murdered. So they want justice for her family, and for the public. Whether that means, though, that his having spent 28 years in prison, they're confident he did it. I assume they're confident he did it. And now they think that they cannot prove it to any jury. Perhaps they will try to get a guilty plea. On the other hand, I wouldn't be shocked, considering it's a 9-year-old here. I wouldn't be shocked if they retry it. I don't think they will, but I definitely have to say it would not be shocking to me if they go ahead with a 4th trial, considering it's a little girl here.
Wow, that is quite the analysis, and that was a picture of her that you just saw up on the screen for those of you watching, of that 9-year-old girl. How sad is this? But as much as we want to have justice, the reality is the state needs to prove their case beyond any and all reasonable doubt. And the fact that we are sitting here as a 4th potential trial looming around the corner because they couldn't get a verdict on this one, that it was a complete deadlock, that seems to me that we are wasting state resources in trying this again. But there's always an opinion, and everybody has their own opinion, and who knows what the prosecution's going to do and how strongly that state attorney's office feels about this case. We will continue to monitor this for you. If we have any updates, we will let you know. And obviously, if we cover this trial a 4th time, you can expect to come here to watch that coverage, gavel to gavel, either live with us or on our network. Let's switch gears again and go back to our main trial, which we're covering right now, and it's the Van Dyke trial, where the former cop in Chicago is standing trial for murder for shooting and killing Laquan McDonald 16 times, unloading his gun. And the question is whether or not this was reasonable or excessive force or justified. Right now on the stand, we're going to hear from Dr. Hakes Carissa. He's a forensic pathologist. And then we're going to come back to analyze that testimony. Welcome back. I'm Carissa Kranz, and you were listening to testimony right there from Dr. Hakes Carissa, a forensic pathologist, and she was going over pictures and images and her analysis of the body of Laquan McDonald, the victim who died at the hands of the former officer in Chicago in 2014. The question is whether or not this is reasonable force or not. With me, Francey Hakes, what do you take away as important testimony from this state witness?
Well, the most significant thing here, Carissa, was Dr. T said that, in her opinion, either the first or the second shot was to the victim's chest, and therefore he had to have been facing Officer Van Dyke when those shots were fired, or that shot was fired, depending on whether.
But why is, I don't mean to interrupt you for a second, but why is that key? We've all seen the video, and we see that he's shot first. I see it as he was shot first. That caused him to spin around, and then 15 other shots were unloaded after that. So it makes sense to me that the front of his body and the back of his body and even the side of his body could be hit. I mean, look at the video. There he is. He's running away. Okay, he's running towards a cop car. Now he picks up his pants. He crosses the median. Now he is going to cross the other median away from the cars before he is shot right there. Okay, and then he spins. See, that spin, I don't know. I look at that. It would make sense that he is shot in the front.
Yeah, I think the argument being made by the defense, Carissa, is that McDonald turned first to the left toward the officer. and that is when he gets shot the first time. He has a knife in his right hand. He turns slightly toward the officer. And listen, people accuse me all the time of being too pro-law enforcement, but here you can see in that video, and I just noticed it for the first time after seeing it multiple times, there's a car that was obviously just ahead of Laquan McDonald. So this is a public street. There are potentially people around. And the defense is just trying to make the argument that he spun to his left facing Jason Van Dyke, and that therefore Van Dyke's thought that he was making an aggressive move, is reasonable. That's the argument.
Okay, so we do need to take a quick break, but when we get back from this break, we're going to go into more testimony from the forensic pathologist, look at that video again, and have more in-studio analysis. Stick with us. We will be right back. Welcome back. I'm Carissa Kranz, and that was testimony from use of force expert Yuri Patrick, the prosecution's witness. And this is key in the Van Dyke trial, because the question is whether or not the deadly force used by the defendant Van Dyke was reasonable and justified under the circumstances. And you just heard him say, not in his expert and professional opinion, was deadly force acceptable. He did qualify it and say, yes, he was an imminent threat at that time because he was armed and he was up to other criminal activity, but that he wasn't an imminent deadly threat. He wasn't taking actions towards any officer or person. He wasn't pointing the knife that he was armed with towards any officer or person. And in fact, the very opposite, he was heading away. Francey Hakes, former federal prosecutor, I want to give you the opportunity to comment on the testimony we just heard and add some additional legal insight on that testimony.
Yeah, Carissa, you know, it's interesting. Again, I give police officers a lot of deference because they do have to make these split-second decisions in situations that I have fortunately never found myself in. And I think it's a little harsh to say that that no one was in any imminent threat. As I said a few minutes ago, there was a car not very far, 20 or 30 feet in front of Mr. McDonald that had just gone by. He was walking on a public street. It's very hard to tell whether there were any sidewalks or any people that were in his path if he had continued to walk along that path. So I think this is a much harder case than it at first appears. When you just see the video and take it only by itself, it certainly looks like an unreasonable use of deadly force. But you have to take it in context, which the jury will. What was McDonald doing before that? What did the police know that he was doing? Why didn't he refuse their commands to drop the knife? And was Officer Van Dyke's belief that he or the public, you have to remember, it's not just him, but the public, were he or the public in any risk of receiving a deadly or serious bodily injury at that time? Was that reasonable?
I think the takeaway point here, when we keep seeing these kinds of cases continuing to show up in our news and in our media, is that when an officer comes on scene, we really just need to comply and do what we're told to do. In this case, it's unfortunate he was already into trouble, but we have to take a quick break. We'll be right back to dissect this further. Welcome back. I'm Carissa Kranz. That's testimony from Officer Tyler Sage with the Westmont Police Department, and he is giving insight for the defense's case of his interactions with the victim, Laquan McDonald, and the kind of character the victim had, the kind of difficult personality he had, the kind of criminal he was before the incident on the night in question, for which the defendant is actually now standing trial for murder. With me, Francey Hakes. I want to give you the opportunity to give some commentary on what we just heard on this defense witness.
Yeah, Chris, I think this is designed for the purpose of bolstering the credibility of Van Dyke's reasonable belief, is what the defense will argue, reasonable belief that McDonald represented a danger, that he was not responding to commands, and that he was acting in an aggressive, threatening way. And so they're trying to show that he was acting in an aggressive, threatening way other times in order to prove that that's likely the way he was acting on this particular night, making the officer's use of force reasonable.
Now, Francey, would you say that it matters whether or not the officer that pulled fire, the defendant in this case that unloaded 16 shots, was aware or knew of the victim's inability to comply in the past to commands, and that there were other incidences? Is that relevant here, or is that irrelevant?
No, I think it's relevant, and certainly the prosecution will make that argument. They will say that Van Dyke had no idea that McDonald had that history, but the defense will say that Van Dyke's knowledge of McDonald's earlier behavior is irrelevant. What was relevant is that this is how McDonald acted in the past, and so you can believe Van Dyke when he said this is how he was acting on that night.
Okay, so let's take a look at some additional testimony from Officer Tyler Sage and see what happens and if the state actually cross-examines him on all those things you just anticipated. Let's take a look. Welcome back. I'm Carissa Kranz, and that is testimony from the use of force expert, Yuri Patrick. And he is breaking down what it is to use excessive force, reasonable force, and under the circumstances when an officer should use deadly force or not. This is to be applied to the Van Dyke trial, where the former officer is standing trial for murder of shooting and killing Laquan McDonald. With me, Francey Hakes. While we were listening to this testimony, you, me, and the control room, Kamana, were discussing whether or not it is reasonable for officers to be taught in training to shoot in the torso to defuse a threat. Why not the leg instead? And to me, that seems shocking. And also in the control room, we were all discussing this, it seems shocking that that's how officers are trained to defuse a threat. And then you mentioned what our Vincent Hill, who's Law&Crime host as well, and a former cop, said on the network recently, that is actually how they're trained. They are trained to defuse a threat by shooting in the torso. That doesn't make any sense to me. That seems awful.
Yeah, well, I mean, Carissa, the point is that you're diffusing a threat to yourself or to the public that you perceive as being a deadly one. That is, someone is maybe going to kill you or a member of the public. And there's only one way to guarantee that that threat stops, and that is to shoot in the center mass to take them down. You know, it's only done on TV and in the movies where you shoot someone in the leg and they fall and are immediately disabled. I can't tell you how many cases of shootings I have heard where people continue to fight, continue to battle, continue to combat police, even when shot multiple times in the arms and in the legs, especially if they're high on drugs. They continue to represent a threat. So police are taught, shoot at center mass to get that threat down, and that's what they do.
Okay, so you bring up an interesting point. If the threat is perceived, and that's the key word, perceived to be deadly, then they are taught to shoot at the center mass. But in this case, he had a knife in his hand, not a gun in his hand. He was not in close proximity with anyone. Why not just shoot him in the leg and disable him? It's not like he could then shoot the weapon in his hand. He had a knife in his hand, not a gun in his hand. That would have disabled the threat. That would have diffused it. And then the officer that arrived on scene, who unloaded 16 shots within 30 seconds of getting out of within 30 seconds of arriving and 6 seconds of getting out of his car, maybe could have had a more accurate perception of the facts of what was going on when he arrived without taking a life. That would be my argument as a prosecutor. Yeah, I'm a former prosecutor, but I look at this video and I think that while he may not have been an innocent victim, he certainly wasn't a victim that was posing deadly force that would justify a deadly force response under these circumstances.
Well, Carissa, a knife is a deadly weapon, and
yes, but they weren't. He wasn't close to him.
No, but it's not. But he could have closed the distance. That's the point. Is that he could have closed the distance, even if he was shot in the leg. He could have closed the distance and hurt someone with a knife or killed someone with a knife. That's why police officers are taught you don't shoot them in the leg when they have a deadly weapon or they represent a deadly threat. You shoot them in the center mass so that they go down, and that ends the threat. Now, can I just say that what this expert witness just testified to on the stand is very distressing, in that he said that the shots went on for 10 to 12 seconds after McDonald was already on the ground. That is maybe a different matter. But those initial shots to center mass to put him down because he's carrying a knife don't seem unreasonable the way police officers are trained.
Well, I guess everyone's going to agree to disagree on this one. Everyone's going to have a different perspective, and that's why there's a trial, and that's why the jurors will get the opportunity to weigh all the testimony and evidence. We have more testimony from the use of force expert, Yuri Patrick. So let's take a look and hear what else he's got to say. Welcome back. I'm Carissa Kranz. That is testimony from Scott Patterson with the FBI Supervisory Special Agent Force, and he is testifying on ballistics. He is explaining the shots that were fired and arrows that he has on the videos, which help him break down what shots were fired when and possibly a time frame. Because remember, we don't have audio on these dash cam videos of when the victim, Laquan McDonald, was shot and killed by the officer, the former cop standing trial right now, Mr. Van Dyke, for murder. The question is whether or not it was reasonable under the circumstances to shoot and fire and use deadly force, and whether or not it was a viable threat. I took away a couple takeaway points on this. The first one is that this expert said that it is consistent with gunfire to have a contortion of the body and quick movement, which is exactly what I was saying earlier today when I was looking at that video. When the victim is walking away and crossing the median, and though you can't hear the shots fired, you see him spin around. Earlier today, some of us were unsure of whether or not that was him provoking an attack and lunging and creating a threat towards an officer. But I saw it as, and this expert just confirmed consistently with what I said, that watch this video right here. He's crossing the median. He's walking away. Up. No, see, it almost looked, if you do that again, it almost, I'd like to replay that again if we can. If you look, his left shoulder pushes forward before his right shoulder spins him around, which is consistent and indicative of being shot first before he spun around. Let's look at that one more time and then bring Francey on to discuss it. Look at this. Watch him crossing the median, okay? Watch. And then look at his left shoulder. It's going to contort forward before he spins around. There it is. Oh, there it is. See? And then he's fell to the ground. And then that smoke, as the expert said, is indicative of debris, not other shots. Francey, what do you make of all that?
Yeah, Carissa, this expert is really significant, and he is trying to talk specifically about the order of shots, and he notes that the normal things that we would see in order to determine when the first shot was fired, so that we could see the position of the officer and the position of the victim when that first shot was fired, would be muzzle flash or the slide movement or the recoil, and that he can't see any of that. So what that means is all he has to go by is looking at Laquan McDonald's body. And, you know, I think we all see it, but we all see it slightly differently. It does look as though he turns first to the left and then is spun around. Why is he turning to the left? Is it because he's already been shot? Is it because
I see it like that. I see it as he was shot. It was a quick contortion of the body, and then he spins around, and then he's just shot down. That's how I see it.
Right. You may be right about that, and the jury may see it your way, but they may not.
Francey, we're done for the day. Thank you so much for your testimony. I also have to sign off, but you can continue to watch us on the network and join us tomorrow at 9 a.m.